right, we're ready to start. Welcome, everybody, to our special broadcast today for Bateman Funeral Home. And we actually have something a little bit different today. We're doing an interview, and we're doing an interview with Brian Haggerty. Some of the things that we're trying to do for our customers and our families is to help provide them with different tools and resources to be able to help prepare for that end of life eventuality that will take place. And that might be for yourself, or it might be for one of your loved ones. And so today, it is my pleasure to introduce Brian Haggerty. And he is a lawyer here in Newport, and he works around in our county, Lincoln County, as well as I'm sure other parts. And I'll let him talk a little bit about that. But he specializes in wills and estate planning and trusts and elder law. And those are the things that you're interested in, and that's why you're watching this video. And he has a bachelor's degree in journalism from Michigan State University. And he graduated from there in 1979 and earned his Juris Doctor's degree with a certificate in federal tax law from Northwestern School of Law of Lewis and Clark College in 1997. And after he passed the bar in Oregon, he began working that following year. And in those between years, he's been spending 12 years as a tax consultant and keeps current on tax laws and aspects of his legal work. One of the other interesting things, and then I'll let Brian talk, because it looks like he's ready to talk over here. But he's very involved in our community, and I'm really proud to be able to introduce him today because he is so involved in our community. He's been a firefighter captain with our volunteer fire department here. He's a EMT with the Newport Fire Department, and he's on the boards of the board of director for the Pacific Communities Hospital Foundation and the Oregon Coast Community College. And that keeps him very busy. So thank you and welcome, Brian.
Thank you. And pleasure to be with you here today on the broadcast.
So we're going to talk a little bit about what you do for our families. And, a lot of times we get families that come in here and they're lost. They come in and they're just like, what do I do next? And those are some of when I hear those words, my heart just drops because I'm thinking, oh no, you've got a lot you're going to have to do in a short period of time. And those are a lot of the people that we send over to you because they just really don't know where to start. And so maybe we can start and talk a little bit about, what happens if a family member has died without a will or a trust? What happens?
Well, that highlights the fact that everybody has an estate plan. It's just that some people have a plan that's going to work because they've done the work, and other people have a plan that ensures chaos. Not having a will or trust or something that states your desires for what happens with your estate. If you don't have a will, your family will step through essentially the same process that they would if you had a will. It's just that you would have given up your chance to give your testimony about what you want to have happen with your estate. And instead, it will go as the state legislature set things up for people who don't have a will. That scheme, which is called intestacy, and that scheme pretty much follows what people would want to do. If you're married and all of your children are children of that marriage, then your wife inherits everything.
Okay.
If you're married and you have children from another relationship, then your wife gets 50% and your children get 50%. Oh. And there's a whole hierarchy of steps that you go through to determine who actually inherits. And as I say, it's close to what people normally would want, but if you haven't done a will, then there's no way of getting gifts to your friends or neighbors or charities that you support. Those things just kind of came off the table because you didn't do that planning step.
So if a family then if a person passes away, am I right when I heard this that if they had maybe children from a previous marriage, if they wanted their current spouse to receive it all, that's not going to happen unless they have a will that states that.
Exactly.
Okay, that's good to know. That's really good to know. I know that a lot of families will come through here and maybe they don't have a whole lot. They maybe they're just on state assistance and there's not a whole lot there, and so there's really not that huge of a need for a will. But we've also had the situation where somebody dies of a surprise. Maybe they were in a car accident or they were something like that happened, and they don't have anything. I'll have people go, well, do I now have to go through probate? And I'm not a lawyer, and I tell them that right immediately. Full disclosure, right now, I'd say I am not a lawyer. You're talking to the wrong Brian, but but can you tell us a little bit about probate? Because everybody's heard that word, either terrified about that word, or they're like, well, it's not that big a deal because we don't have much anyway. So talk to us a little bit about that.
Right. Well, probate is a process that is ancient. I mean, it's hundreds of years old. I should say at this point, everything I'm going to say today is about Oregon law.
Okay.
And
Thank you.
States have their own ways of doing things. People who are coming out of California have learned that probate is a very bad, expensive, time-consuming, ugly process.
Right.
Because I guess it is down there. It's not in Oregon. And the basic idea of probate is it does all of the things that need to be done. It makes sure that the decedent's creditors get paid, that his taxes get filed and taxes are paid, and then that the estate gets distributed to the people who are entitled to it, either because you left a will or because you didn't leave a will and the state laws regarding intestacy come in. But at the end of the day, with probate, you get a judgment from the probate court and it says you're done. And that's a nice feature because that draws a line in the sand that cuts off people. People can't come in 2 or 3 or 4 years after you're done with probate and say, wait, I was entitled to something.
Right.
It's a done deal at that point.
So thank you. Is that one of the reasons why sometimes there's like a requirement to post that somebody has passed away in the newspaper? I'm sorry to kind of throw that out there, but
yeah, no, that's fine. The newspaper notice is still required, but it's quickly becoming kind of irrelevant.
That's what I've been hearing. So
yeah, because the only people who read the newspaper notices really are air search firms that are looking for places where they can get paid.
Got it.
To put somebody in touch with an estate.
Okay.
But so years ago, the U.S. Supreme Court decided that newspaper publication was not really noticed to anybody. The administrator of the estate has to make a diligent search for creditors, has to actually read the decedent's papers and say, here's where I think money is owed.
Right.
And then contact those individuals directly.
Okay. So I've had people talk about joint ownership, my wife was on the title of the car and on the house and in the bank and all that kind of stuff. And so if I die, she's going to get everything anyway. Is that kind of a workaround, or does that replace a will or a trust or that type of thing?
It's very handy between married people.
Yeah.
And very frequently, married people do own essentially everything jointly, so that when one passes away, the other just inherits everything. And that may work fine.
Right.
But if you have children from a prior relationship and you want to make sure they're protected, then you do want to make the will and make sure that and leave some assets that aren't jointly owned. The thing about joint ownership is it comes in prior to when the will is considered. So your will can say whatever you want it to say, but if you owned everything jointly with right of survivorship, then your spouse owns it all, and your will doesn't speak at all.
Right. So that really, if everything's joint, it's just all going to go through anyway, and you really, okay.
Right.
That's good to know.
That can still often work between spouses, but when you get joint ownership with one of the kids,
Right.
you start to create more problems, because then that child inherits a whole bunch of the assets, and maybe
Right.
your plan is equally to all of my kids,
Right.
but now you just defeated your plan. Your will doesn't necessarily speak, but the joint ownership takes over and takes control.
Yeah, I've had people also as well say, well, Dad put me on the house title before he passed away, and so we don't need all this. But like what you're saying there, that creates a problem, because one of the children is now owning that home, and there may be 3 or 4 kids, and so they may have to sell that home now immediately in order to be able to help. If the will says or to divide equally, then it becomes a problem.
Right.
It can become a problem.
It can become a problem before you pass away as well, because people talk about putting my son's name on the deed, or putting my son's name on the house. That's not what you're doing. What you're doing is deeding an interest in the property to that child.
Right.
Now if he gets divorced, it's an asset in his divorce. If he runs into tax problems, your house might end up with a lien on it.
Yeah.
He runs into creditor problems or identity theft, your house may be on the table. And finally, if you decide to do something different, if you decide to sell that house, now you need to go to your son with your hat in your hand and say, son, I want to sell the house. Is that okay?
Right. Yeah.
Most people aren't ready for that conversation.
No, that can really cause some problems. As we were talking about this too, there was something like we'd talked about before. It's one thing to be a signer on a bank account. It's another thing to be a joint with a bank account with your mom or dad. And I think that's for the same reasons what you just said. If I'm on the bank with my dad as a joint owner of that account, then that creates more problems than if I can just be a signer on that account, right?
Yes. Well, by signer on the account, what we're really talking about is being an agent under a power of attorney.
Exactly.
So you are doing transactions on behalf of somebody else. If you've been added to an account as a joint owner, you're an owner.
Yeah.
And you're not an owner of half. You're an owner of the whole thing. You can write a check that empties that account.
Ooh.
And the bank is not wrong if that happens.
Yeah.
Which one of the reasons that the banks like that, it's easier for them, and it completely absolves them from responsibility.
Yeah.
Well, anyway, there are a number of reasons why joint ownership can work as an estate plan in very limited circumstances, and you need to be careful to pencil out exactly what happens to each of your assets so that you know. The other sad thing sometimes about joint ownership is that you'll get everything except one account or 2 accounts,
right,
or a car and a couple of accounts. And so you end up having to do a probate for a very small amount of assets just because they were left out of that joint ownership scheme. You need to be very careful with it.
Okay. That's great advice. And for those people that are listening, this is some good information. Hopefully you're taking notes and you can go back. My daughter mentioned to me, she's our social media expert, that this is going to be recorded. And so you'll be able to go back and look at this again if you're missing anything. For those that are joining late, this is we're having a special broadcast on Bateman Funeral Home today with Brian Haggerty, and he is a local lawyer here in our community. He's very involved in the community and very experienced. And so, and if you want to go back and listen, you can hear about all of his great credentials. So we're going to move forward. We have a couple more questions that we want to get to today. And one of them is estate. What is an estate plan? And, we've talked about a lot of stuff, but what is an estate plan and what would kind of go into that estate plan and why would you want one? I mean, we've been talking about some of the issues, but kind of walk us through a little bit of an estate plan You got 2.5 minutes. I'm kidding. Go ahead. It's an easy thing, right?
First you need to look up the word plan, which is a coordinated series of steps that reach a goal. About half of everybody out there in Oregon doesn't have an estate plan at all because they haven't set up any coordinated series of plans that reach a goal, or a series of steps that reach a goal. So an estate plan is thinking through, what are your goals? What do you want to see happen with your things? Now, first of all, modernly, we have to provide for before you die, during some time when you're incapacitated, but you're not dead yet. You need to have some way of managing your assets and taking care of things. And then when you do pass away, what do you want to see happen with your assets? So an estate plan is all about the individual's goals for what he wants to see happen before he dies, after he dies. That said, there are a lot of different valid goals for an estate plan, and there are a lot of different people out there with different ideas. So it gets pretty complex pretty fast. Yeah. Once you start building the plan, though, and once you've identified your goals, then you can see how to reach those goals.
Okay. This is a little bit off topic, but can't you just go to the website, rip off one of those things off of the web page that you see that says free estate plan, and
yes, you can.
And then you get what you're
going to do that. What I always tell people, though, is your will is going to be the last thing you say on earth.
Yeah.
It's got to be perfect. In overwhelmingly most of the cases, it can't be fixed after you pass away.
Yeah.
So your family may pull out a document that you thought you drafted right, and what it does is it disinherits someone, or it fails to disinherit someone who should be.
Yeah.
It creates all sorts of confusion, or maybe it's just badly worded. Maybe it's missing things. The stuff you're going to get off the internet mostly doesn't come out of Oregon. It mostly comes out of New York, Texas, California, Florida. They're really populous states. And their laws are going to be really different from ours. Yeah. So you often see an internet will that says it's subject to the laws of California. And this is something that was signed by a guy living in Oregon, who's lived in Oregon all this time. It just creates confusion.
Yeah, and we've ran into that here a few times. And one quick, we have a question coming up, but one quick point. Once you've spent all that time getting the will and everything, put it in a safe place and make sure somebody else knows where it's at. Because we had a family that was looking and looking and looking, and all of a sudden they found it stuck inside of a recipe book. So, and fortunately they found it before they really needed to get it. But boy, it's important to tell somebody where you're putting it. So, Lauralee, can you read the question to us?
Jason asks, what do people on disability who can't afford burials, what options are for them?
So people on disabilities that can't afford burials, what options are for them? Okay. And what we'll do is, that's a little bit off topic here, but there are a number of different things that you can choose, Jason, which would be cremation, that type of thing. And there are some pre-arrangements that you can do. And if you want to make a little note in there of contact information, we'll definitely contact you afterwards. But thank you for the question, Jason, and we'll certainly follow up with you. How often should you update an estate plan? I've got one back when I was in the military, and I've only been out for 25 years. Do I need to update that?
Yeah, probably. We recommend about every 3 years.
Okay.
But you also want to update your estate plan if you get married, if you get divorced. You may want to take a look at your estate plan if you start having grandchildren, or you have one more grandchild. So there are life events that should put you in mind of, I need to check my will. your will and beneficiary designations and things like that. If you've got an IRA, you want to have individual beneficiaries named on that IRA. Don't change your will and forget to change the beneficiary designation.
Right. Definitely.
So, but about every 3 years.
About every 3 years, you said then?
And that's just take the will out, take a look at it. If it still says what you want it to say, you put it back into the safe deposit box and you're good.
That's good. So we get, and I shouldn't say we, but I know that I've had conversations with people and, you get into revocable and irrevocable and what is a will and what is a revocable trust. And I know that it could probably get pretty complex, but can you give us just a brief idea of the difference between having a will and having a trust? And then maybe talk what is revocable, what's irrevocable.
Okay. A will and a trust are completely different and exactly the same.
That's not confusing.
The revocable trust, which is the kind of standard way of avoiding probate, it's the standard will alternative. The revocable trust does exactly the same things as a will, but it does them in a completely different way. The revocable trust, you actually fund during your lifetime. You transfer all of the assets that you own to the trustee of the trust. And then the trustee of the trust is now responsible for those things. When you pass away, the trustee of your trust has to do all of the same steps that you do in probate. You have to check for creditors, make sure that tax returns are paid, and then distribute the way the trust says. The basic difference between a will and a revocable trust is that the revocable trust requires you to do a lot more work during your lifetime. You have to see to the transfers to fund the trust, and then you have to keep an eagle eye on all of your assets and make sure that they're all held by the trustee of the trust.
Right.
If you don't, if an asset that isn't owned by the trustee of the trust has to go through probate.
So you can end up doing both.
Conditions where you've got half or more of the estate in a revocable trust, but the other half was left out for some reason. Now you have a trust administration and a probate estate. You don't want to go there. The real advantage to the revocable trust is that it allows for better management of your assets during that period of incapacity.
Right.
So if you've gotten a diagnosis that says that you've got Alzheimer's and you're going to lose capacity over time, that might be a time to think of a trust. And the real key to the trust is there someone that you can rely on absolutely to serve as your successor trustee? The successor trustee will take over when you pass away or become incapacitated. And that person has to be absolutely honest and absolutely businesslike. Has to be the kind of person who gets stuff done, because the court won't be there, prompting and saying, you need to get this done, get this done.
Right.
So
that's a good point. So there is a difference then between being the essentially the person that's in charge of the trust and maybe a power of attorney, because you can actually split this up to where you can have one person in charge of the finance part when they would be in charge of the trust, and you may have somebody else that does the power of attorney for medical and that type of thing. So because again, the power of attorney, and we've talked about this before in some other videos, that actually ends upon death. Whereas the person in charge of the trust, it still continues until the trust is dissolved, correct?
Right. Yeah.
Okay.
And also, with power of attorney, financial institutions don't have to do what the agent under the power of attorney tells them to do. They can just say no.
Right.
Whereas the trustee of the trust is the legal owner of the assets, and so has all of those powers as the owners of the assets to make things happen.
And that's why they got to be absolutely honest and trustworthy.
Absolutely honest. Yes.
Well, and that's the, and I know we're really starting to we're getting deep into this, but we've had conversations before when somebody comes in here to maybe do a pre-arrangement, and I like to tell them, I said, a lot of times people say, well, my oldest child. Well, maybe your oldest child isn't the best child to do it.
Right.
Maybe it's your youngest child or an in-between child type of thing, or maybe not even a member of your family. Maybe it's a cousin or a brother or somebody that you absolutely trust, and they're going to get it done, and they're not going to have to deal with all of the emotions that are going on at that time. So, and it may lawyers, like such as somebody like yourself, you can be appointed to run that trust, correct?
Yes, although that's a relatively expensive option.
See, look how honest he is right there.
There are people who serve as professional fiduciaries.
There we go.
And so that would be a better choice, because that's a person who's accustomed to doing things but isn't necessarily charging lawyer rates.
Okay.
Because a lot of what you need to do as the trustee of the trust isn't legal work to that extent. It's selling property.
Right.
Or, just handling a checkbook and things like that. Right. It's ordinary stuff that ordinary people can do.
Right.
They just have to do it. They have to do it timely, and they have to do it carefully, very, very diligently.
Okay. So we're just about done with our questions. I do have a last question though for you. So What should the audience bring with them if they're going to have an appointment with somebody to do estate planning? What should they bring with them to that first meeting?
What you need is an estimate, a fairly close estimate of what assets you have. Always keep the retirement plans, IRAs, 401ks, 403bs, keep those in a separate column. But we need to know approximately how much is in there, and then if beneficiaries are named. And then, your house and any other real property that you own, your bank and brokerage accounts, not with exact figures necessarily, but with good close estimates. And then we need to know who's in the family. Usually at an initial interview, I'll be drawing a family tree because it helps me to have a picture. Sure. But who's in who are the players that we need to consider in this? One important thing that people are often unready for is who will be your fiduciary. The fiduciary is the person who takes control of the estate. That's either your personal representative, the person who's going to administer a probate estate, or your successor trustee. We need to know who those people are and an alternate in each case. And as you say, it's not necessarily the oldest son. Usually the oldest daughter.
Well,
I'm sorry, but it just is. In most cases, it's the oldest daughter. But it's basically you're looking for that person who is businesslike, diligent, honest, willing to put him or herself a step behind everybody else, because that's the key to a fiduciary. If a fiduciary is splitting up $1 into thirds, the fiduciary is going to take the 33 cents.
Right.
Right. And
that's a great point.
That's something that a lot of people aren't very good at. And so that's something that you need to consider. Who's going to be my fiduciary? Who will take the 33 cents?
Yeah, that's a great way to put that. Well, Brian, thank you for your time. We appreciate you being able to kind of help us through some of these questions. I want to give you an opportunity to maybe give us a plug. What would they, if they were to try to figure out more on financial planning, how would they get a hold of you?
Well, as it happens, I have a seminar coming up. It's going to be a Zoom. It's the first time I'm going to be doing this seminar on Zoom, and that's through the Oregon Coast Community College. If you contact their Lifelong Learning, the Catch the Wave catalog that you see come out, my class will be in there. We're starting on Tuesday, October 6th for the next one. And that goes through what is a will, what is a trust, what's probate, what is trust administration. We also talk about those healthcare directives
Oh, yes.
and power of attorney and things like that.
Yeah. Do they have to be a member of the Lincoln County community, or can they be from outside, like over in Benton County or Lynn County or anything?
It's a really interesting question. Of course, we've always been dealing just with Lincoln County, but I don't know. I will have to contact the Lifelong Learning Group and find out whether it's going to be posted anywhere.
All right. Well, if you're watching and you want to attend and you're outside of the county, check back, and when we know the answer, we'll also drop it into the notes here. Laura Lee is taking notes, and she'll let people know if they can attend remotely from Portland or Salem or Puerto Rico.
Or anywhere. All right. Well, thanks for having me on the show. And I want to say, as a parting thing here, anybody listening, if I've said something different from what your estate planning lawyer said, please don't call him up and say Haggerty says you're wrong. Because I've been talking in broad generalities, and
right.
Certain things about your estate plan that drive certain decisions. So
exactly.
That's not what I'm saying.
Well, Brian Haggerty said. Well, thank you very much. We really appreciate you taking your time. And anybody that has any questions, feel free to drop some questions down below. Make sure you click that you like this. If you know somebody that that you think needs this information, please forward it on to them. And we'll be checking back and answering questions later on. Thank you very much for listening to our show today, and we will have another one here in the near future. Thank you very much, and bye, everybody. Thanks, Brian.
Bye.